Prima Facie. Is it the name of a fancy restaurant?
Buongiorno. Alla Prima Facie.
Well, of course not. Prima facie and its literal Latin translation of at first sight. You know, what does this mean, and really the utter importance thereof for you as an officer in the field endeavoring to charge someone, and now, of course, this charge even having a plausible opportunity to be entertained in court. Well, it is exactly this and more that we'll be definitively going through. You'll definitely want to check this out. Court is in session. You're on the stand with me, Brian Lass. Roll the intro. Well, welcome once again. I, of course, am Brian Lass, and if you have not done so already, I will extend an invitation from my side of the computer screen to yours. Go ahead, click that subscribe button and bell notification icon below to make sure you are first in line for notification right to your email inbox of videos just such as these. So go ahead, click that subscribe button. You did it. It's done. Let's move on. And yes, prima facie, or rather, as we've discussed, Latin for at first sight, or rather another way to describe this is proper on its face. But again, although this language is somewhat elusive, what does this really mean for us as an officer in endeavoring to charge someone in the field? Well, another way to give a more succinct definition is that prima facie alludes to evidence that, unless rebutted, would be sufficient to prove a proposition or fact. So certainly in full appreciation that as it relates to a matter going to court, every essential element of that offense must be proven beyond a reasonable doubt. Well, guess what? Right from the onset, if any one of these essential elements or fact and issue is not even referenced, is not even, anywhere to really be noted in the evidence, whether it's your memo books, incident reports or otherwise, it's the difference between, again, a matter going to court and perhaps a finding of guilt, or for that matter, in a Part 1 provincial offenses context, a prosecutor will deem no reasonable prospect of conviction, will never entertain a trial, or for that matter, any proceeding by way of an information. There's no way this information is ever going to get past the gatekeeper, the justice of the peace, to be placed on a docket. So, for that matter, how do we best ensure that we've laid a good charge, or i.e. that we do have a prima facie case? Well, let's use one of my favorite go-to statutes, the Trespass to Property Act, the provincial offenses type example here, and let's go right into the PowerPoint and break this down step by step. So again, in endeavoring to put our mind to the idea of ensuring we have a prima facie case, or rather that it is proper on its face, as we've talked about, we could certainly think about it in the context of who, what, where, when, why, and how. And of course, the facts and issue and affording evidence for all the essential elements of the offense. Or to take it one step further, as for such example, we could think of it in the context of having to be able to speak to every single item that would be on the face of, as pictured here, a Part 3 summons. For such example, we have obviously the date and time of the offense. We have the particulars of our defendant, Joe Smith. Did we actually satisfactorily ID Joe Smith? That's going to be one of the things that a prosecutor or a justice of the peace is going to want to know to figure out, am I even going to let this matter go ahead to trial or be placed on a court docket? Certainly as it goes on, we have the further particulars down below, the birth date of the defendant, certainly the location, jurisdiction being a big one, the city of Toronto. Now, as it relates to the actual offense itself, and again, here we're using a straightforward example, an offense under the Trespass to Property Act of engaging in prohibited activity on premises, again in appreciation that every essential element of an offense need be proven beyond a reasonable doubt. Have we afforded, at bare minimum in our memo book notes, the idea that, well, guess what, every essential element that comprises this exact offense has been spoken to, has been afforded, and is part of the equation. And we can certainly get a little bit more specific at this as we advance the slide and we look at the long form wording, as for such example, of this fictitious charge that we've laid upon Joe Smith. So, of course, here we have the long form wording of the respective fictitious charge we're laying upon Joe Smith, the idea of engaging in prohibited activity on premises, Section 2, Sub 1, Paragraph A, Clause 2 of the Trespass to Property Act. And it is by no coincidence that I've really bolded or highlighted certain parts of this long form wording, be that these would be considered the essential elements that would have to be afforded in your evidence, and again would make the difference of whether or not a prosecutor would figure out if they have a reasonable prospect of conviction in a Part 1 context, or if it's a Part 3 charge, whether or not a justice of the peace will even swear to an information and allow this matter to move forward throughout the court process. So if I switch on my fanciest of laser pointers here, again, every person, well, again, we've already talked about the idea of satisfactorily solidifying identification, which we'll just say for all intended purposes we've done. Maybe it was an Ontario driver's license, not acting under a right or authority conferred by law, and without the express permission of the occupier. So certainly your evidence would have to allude to the idea that, this person, Joe Smith, was not considered an occupier under the definition of occupier in the Trespass to Property Act, wherever you lay this charge. And for certainly continuing on, proof of which rests on the defendant. So again, it would be incumbent upon the defendant. You would have to speak to the fact that the defendant failed to satisfy you, failed to provide you with any such evidence that either they're an occupier or that they had the express permission of someone who would be considered an occupier in this area. To be able to engage in whatever activity it was on this respective premises. Of course, we have to talk about the premises, the actual municipal address, the jurisdiction. Again, we've done that, City of Toronto for this fictitious example. But as it relates to this, prohibited activity, again, we can see here the activity is prohibited under this act. So what does this tell us? It doesn't just end, or it's not sufficient just to speak to whatever would be written here in this long form wording of the charge itself, because again, this is alluded to the idea that proper notice is an essential element, and we need to be able to talk about how this person would otherwise know that the activity they engaged in is prohibited under this act. And of course, the TPA under Section 5, Section 6 talks about proper form of signage. So we would have to speak to the fact that there was a signage, with some kind of notification sufficient as far as the TPA is concerned that would tell someone, hey, you can't do whatever this illicit activity is on the premises. So really the takeaway here, of course, in the field, an officer, an investigator, anyone with a conferred ability to lay a charge upon a person, whether it's criminal or provincial offenses, of course, in the field, we are not judge, jury, and executioner. When we've commenced a proceeding, we've done just that, and it opens the world of court if this matter will even be considered prima facie and allowed to move forward. So again, a further takeaway for certain, get to know your enabling statutes, your enabling legislation. If you're going to go through all that hard work to investigate someone up to and inclusive of laying a charge, of course, you want to ensure that all the evidence is going to be that of prima facie at bare minimum, of course, and be afforded opportunity again to move forward through the respective court process. And with all that having been said, I certainly hope that there's been some beneficial takeaways for you. As always, I appreciate all the positive feedback from these such videos. And that being said, I will see you in the next one. Take care for now.